Hi, I'm Nick Alcock. I'm a criminal defense attorney here in Phoenix, Arizona. I'd like to talk a little bit about being tried in absentia. And one of the things that happens when you go to court for some of your first court appearances, the judge will say you realize if you don't appear, number one, you could possibly lose your bond if you posted one, and the other is that you could be tried in absentia, meaning that if you don't appear, they can just go ahead and call on a jury and just move on with your case. Your attorney will be there, but you won't. And this is something that actually happens quite frequently. It is on a case-by-case basis because there are some people that bench warrant. So while their case is going on, they don't appear, and the case just goes into warrant status. So they're going to wait and not have the trial until the person is either picked up, caught, turns himself in. It's very difficult to win a trial in absentia. It's very, very difficult to vouch for a client, so to speak, get in front, defend a client if the client isn't even there to be defended. You can obviously win. It's more likely that you would win on a technicality, motion to dismiss or suppress for some type of constitutional violation than it would be to actually go in front of a jury and win if your client is not present. Because juries just assume that if you're not there, if you didn't show up for this, then maybe that's a signal that you're possibly guilty. The judge will read an advisement. The judge will say you can't consider that fact, but it's something that juries, unfortunately, they can't help but consider it. And certainly if I were on a jury, it would cross my mind as to why is it that the defendant table only has one person in it and the defendant is not around. The other aspect about criminal defense, which is similar to being tried in absentia, is that if you plead guilty and you say that you're guilty, what will happen is the case will be set for sentencing. Usually sentencing is 30 days out, sometimes it's a couple months out, sometimes 15 days out. And if you don't appear for your sentencing, whatever it is that you agreed to can actually be thrown out, and you could be sentenced to the maximum under the range of the class of felony that you pled to. And this comes as a very rude awakening for people who get nervous, they get scared, they don't appear for their sentencing, they get picked up a couple years later. They think that they signed a plea agreement for a year, and suddenly they're not looking at a year anymore. Suddenly they're looking at 4 years, 5 years, because that was the range of possibilities under the type of plea agreement that they signed. So for example, if you signed a class 4 felony for an aggravated DUI, you think that you're going to get 4 months in jail, you don't appear for sentencing, you could actually get up to 3.75 years in prison. So showing up for court is obviously incredibly important. People do panic and they make mistakes and they think, well, I can't deal with this right now, it's too overwhelming. And really that's why you need to have a good attorney on your side. If that's the case, if you're on warrant status, if you're wondering, what's going on with my case and is there a way to reopen a case, the good news is that there is. And people that turn themselves in and people that take sort of initiative and get back into the game are treated much, much better than people that get picked up on a warrant status. And there are things that a good defense attorney can do to get you back into court without you being punished excessively. So if you have a warrant right now, if you're worried about being tried in absentia, give us a call, 602-989-5000, 602-989-5000. We're happy to tell you what we know about the criminal system here in Arizona, and we're happy to walk you through what options that you have. So thanks so much for watching. If you have any questions, again, 602-989-5000.